Today, we're diving into something that's super important for anyone with a big loan. What actually happens when a lender has to enforce their security? It's a really powerful legal process, and we're going to break it down step by step. It's a question that probably keeps a lot of people up at night. You've put your house or your business up as collateral, but what's the actual real-world process a lender follows if you default? It isn't just one single event. It's a very, very specific legal playbook. Okay, so it all starts with this one core idea, the security interest. The best way to think of it is as the lender's safety net. When you get a secured loan, you're essentially giving the lender a legal right over that asset, the collateral. And that right only comes into play if you can't hold up your end of the bargain. Now, here is what makes this whole process so incredibly powerful. Under the law, a secured creditor can actually start enforcing their claim without needing a judge's permission first. This lets them move fast, which, from the borrower's perspective, makes the situation really, really serious. So how does this whole thing even get started? While it's not random, there are two very specific things that have to happen. Let's take a look at the trigger. It all begins with a 1-2 punch. First, pretty obviously, the borrower defaults on their payments. But, that alone isn't quite enough. The lender also has to officially classify the account as a non-performing asset, or an NPA. That's basically an internal label that means the loan isn't making them any money anymore. Only when both of these things have happened can the process really kick off. All right, so the trigger's been pulled. Now we're moving into the next phase. This is an absolutely critical window of time for the borrower, and it all starts with a piece of paper. The countdown is officially on. The lender can't just, show up at your door and start taking things. The law says they have to send a formal written notice first. This document lays out the exact amount you owe and makes it official. They intend to enforce their security interest if you don't pay up. And this brings us to the most important number in this entire process, 60. You get exactly 60 days from the day you get that notice to pay the entire debt. And that's not a suggestion, it's a hard deadline with some pretty major consequences. But you're not completely powerless during these 60 days. The law actually gives you a specific right to talk back. You can formally object or make what's called a representation. Maybe you think the amount is wrong or there's been some other kind of mistake, and the lender has a legal duty to actually consider what you've said and reply with their reasons within 15 days. Now, this is super important. While you have this right to object, that notice also puts a brand new restriction on you. From the second you receive it, your asset is basically in lockdown. You are legally not allowed to sell it, lease it, or transfer it in any way unless you get the lender's written permission first. So what happens if those 60 days come and go and the debt is still there? Well, this is where the lender's playbook really opens up, giving them a whole set of powerful tools to get their money back. The lender basically has four main moves. They can take physical possession of the asset. If the asset is a business, they can literally take over the management of it. They can appoint someone to manage the asset for them. Or, and this is a really interesting one, they can legally tell anyone who owes you money to start paying them directly until your debt is all cleared. Taking possession is really just one step. The end game for the lender is always to get their money back. So let's talk about what happens after the asset is seized. The legal power they have when they sell is huge. So what this bit of legalese is saying is that when the lender sells your asset, the person who buys it gets full, clean ownership rights, just as if you, the original owner, had sold it yourself. This is so critical because it gives buyers confidence and, frankly, makes the asset way easier to sell. Now, the money from that sale doesn't just go straight into the lender's pocket. The law has a very strict order for how it's used. First, all the costs of seizing and selling the asset get paid. Second, the lender's debt gets paid off. And third, if there's anything left over, the residue, that money has to be paid back to you, the borrower. That leads to a really common and totally logical question. What if the asset gets sold, but the money they get isn't enough to cover the whole loan plus all the costs? Is the borrower just off the hook for the rest? The answer to that is a hard no. The lender can go to a special court, called the Debts Recovery Tribunal, to legally chase the borrower for whatever balance is left. The debt doesn't just vanish when the asset is sold. And if you've ever co-signed a loan, you need to hear this. The law is crystal clear that lenders can go after the guarantors for the debt at any time. They don't even have to seize the main asset first. This puts guarantors in a really vulnerable spot. Now, of course, not all loans are simple. Sometimes you have more than one lender involved, so the law has some special rules for these more complicated cases. And the magic number you need to know here is 60%. In a big joint financing deal where a whole bunch of banks have chipped in together, one bank can't just go rogue. That's because the law demands a consensus. Lenders who hold at least 60% of the total outstanding debt have to agree to take action. And once they do, that decision is binding on all the other lenders in the group. It basically prevents chaos and makes sure the majority rules. So after all of this, is there any way out for the borrower once this train has left the station? And the answer is yes. There is one final, incredibly important escape hatch. It's called the right of redemption. If the borrower can come up with the full amount of the debt, plus all the lender's costs, at any point before the public notice for the auction is published, the whole process has to stop. The asset can't be sold. It is literally the last chance to make it all go away. So there you have it, a powerful process that lets lenders recover their funds without getting bogged down in court, but one that also has built-in notices, chances to respond, and that one final right of redemption for the borrower. It's a system that's trying to walk a very fine line between two competing needs. So the big question is, do you think it strikes the right balance?